Turn the air back up a little because it's kind of chilly in here. She goes, well, I just turned it down earlier. Oh, sorry. People are playing it out.
That's all right. Okay, we're good. All right, we are going to get started with our next presentation. We have Professor Beyer speaking next, who's obviously a very important part of the estate planning journal. Professor Beyer joined the faculty of Texas Tech Law in June 2005 and is the first holder of the Governor Preston E. Smith Regents Professorship. Professor Beyer has previously taught at St. Mary's University and has served as visiting professor at several other law schools, including Boston College, The Ohio State University, Southern Methodist University, the University of New Mexico, Santa Clara University, and La Trobe University in Australia. He's a recipient of dozens of outstanding and distinguished faculty awards, including the Chancellor's Distinguished Teaching Award, which is the most prestigious university-wide teaching award at Texas Tech. Professor Beyer is a state and nationally recognized expert in estate planning. A highly sought-after lecturer speaking at dozens of continuing legal education presentations for both state and local bar associations, universities, and civic groups. Professor Beyer is the editor of the most popular estate planning blog in the nation, which for the past 4 years has been named the ABA Journal's Blog 100. He's authored and co-authored numerous books and articles focusing on various aspects of estate planning, including a 2-volume treatise on Texas will law and estate planning. He's won awards from the American Bar Association's Probate and Property magazine for his writing 3 times and is one of the most downloaded law professors on the Social Science Research Network. Maybe most importantly, he's the editor-in-chief of the Real Estate and Probate and Trust Law Reporter and our faculty advisor. Today, Professor Beyer will first be providing a case law update, and so please join me in welcoming him.
All right. Thank you very much, Evan, for that very generous introduction. I hope I can live up to it. All right. Now, as you know, what we're going to be doing this morning is looking at assorted recent Texas cases dealing with various aspects of wills, trusts, estate administration, and so on. But before I do so, I would like to talk with you about a couple of other new developments in the estate planning area. One of the things we're going to look at first is looking for a will, because after a client or a person has died and your client comes in, you need to have them look around and see if they can find the decedent's will. And normally what you do is you look in the decedent's files, a safe deposit box, you look with family members, the attorney who drafted it, things like that. Well, there was this woman, and her name was Melanie, and she was not happy with just searching in those normal locations because she was really upset that she did not receive a larger share in her dad's estate. So 11 years after the dad died, what she did is she had no authorization to do so, but she went up to her dad's grave and dug him up because she believed that inside of the grave was his real will. And when she opened it up and got in there, she didn't find the real will, but she did find vodka and cigarettes. In my mind, that now just explained to her why her dad died. All right. But unfortunately, she didn't find any will, and now she's up on charges for criminal mischief and corpse abuse. Actual true story, just was in the news within the last couple of days. Now, another thing that some people do is that they have this habit, thinking about those cigarettes that were found in there. Some people smoke, and that's, it's not so good for your physical health, but it might not be so good for your financial health as well. In this one case, a father, he had power over a discretionary trust. And when he caught his daughter smoking, he just cut her out. And that cost the daughter, not that much, about $550 per month for smoking. But it got worse. In this other case, there was a holographic will, and the father left the property to his 2 daughters to the exclusion of a son. And the son, after the death, said, "Dad always said if I didn't quit smoking, he was going to cut me out of the will. But I never believed him. I thought he was just kidding." And so you learn there that you need to believe your parents when they tell you they might cut you out if you don't stop a particular habit. But it's not always that way. There's another case where it went the other way. The husband died with a will, and this time, for the wife to inherit the house and all the cash, she had to smoke 5 cigarettes every day for the rest of her life. And if she didn't smoke, she'd lose the house and the money. Here's a provision from the will. She could not stand to see me with a cigarette in my mouth, and I ended up smoking in the bathroom like a schoolboy. My life was hell. Now, what I wonder is whether or not, I don't know if the court enforced that. Would a court enforce a provision that required a beneficiary to engage in a dangerous habit to receive property? I don't know. Interesting case. All right, well, enough of that now. I don't know if we have anything that interesting to talk about today, but we're going to look at Texas cases from 5 main areas: intestacy, wills, estate administration, trusts, and then other assorted estate planning areas. Now, we don't have time to cover about the 30 cases that are in your material, so what I'm going to do is highlight the most important and the most interesting ones. And as we go through our discussion, I want you to be sure to pay attention to the moral, that is the lesson we learn from each case, so that we may avoid litigation and frustration of our client's intent. So we come to the first categories of cases, and those are cases dealing with intestacy. Now, in most years, we don't have any intestacy cases. Even though most people die intestate, they don't seem to generate that much appellate litigation. Well, this year we do have one very interesting case. It's the In Re Estate of Aragaz case out of Corpus Christi, and petition has been filed on this case. What happened here is the husband died intestate, and then the mother filed a petition to determine heirship. And the mother's application excluded the wife. And the reason it excluded the wife is the mother asserted the marriage was void because the Texas Constitution prohibits same-sex marriage. The wife, on the other hand, asserted the marriage was valid because she said that even though she was born with male organs, that they had been replaced and she had transformed into a female. That she had spent her entire life living as a female, her name was a female name, and she had completed gender reassignment surgery. Now, the trial court granted a summary judgment that the marriage was void, and the trial court relied on a 1999 San Antonio case which held that gender is determined at birth and cannot be altered by surgical procedures. But the appellate court reversed. How could they justify the reversal? Well, they looked at an amendment to the family code, an amendment to the family code that was made after the Littleton case, which permits a county clerk to issue a marriage certificate based upon a sex change. So that, in effect, this prior San Antonio case was legislatively overruled. And so the court held that Texas law recognizes that an individual who has had gender reassignment surgery is now eligible to marry a person who has the physical appearance of the other gender. Now, the court didn't determine whether this marriage was void or not. They said that was a fact question and sent it back. But we do know now that a person's legal gender may be altered by appropriate surgery, which means that two people who were the same gender at birth can marry each other later on as long as they end up configured as members of the opposite genders. All right, so that was our only intestacy case. We now take a look at wills cases. The first case deals with an interpretation of a provision in a will. This is the Stevens case out of Tyler, and this is also a petition file case. Here we have a husband who was unhappy with his wife. Rather than divorcing her, he murdered her. And then after murdering her, he decided, well, I might as well kill myself too because the state will probably get around to doing it later. So he shot himself. But he was not a very good shot. And he didn't kill himself immediately, and he lived for many hours before he died. Now, why would this be important? Well, the will had a provision that a whole bunch of cash legacies would occur only if husband and wife died in a common disaster. And the whole issue was whether or not this murder-suicide arrangement would be deemed a common disaster. And both the trial and appellate court said yes, because the husband fired both the murder and suicide shot in one episode. And the court said it was irrelevant to the classification of this event as a common disaster that, quote, husband did not successfully kill himself immediately. So we now know that a murder-suicide can be considered as a common disaster if that term is not defined in a will. Now, our next case deals with a contractual will. This is the estate of Finney case out of Dallas. Here we had a contractual will that said, I will give the beneficiary $1 million if she resides with me and takes care of me until I die. But if she doesn't do it, then the $1 million goes to the daughter. Well, what's interesting here, though, first is that, in most contractual will cases, where we see the litigation is whether or not the will actually created a valid contract. That was not an issue in this case. Everybody agreed that the will did establish a valid contractual will, but what the daughter did, of course, the daughter's really upset because she's losing out on $1 million. She says that the beneficiary did not satisfy the condition of taking care of mom. And the jury said, yes. Jury said, yes, she certainly did, and she's entitled to the money. And the daughter, of course, is upset, and so she appeals. The appellate court did affirm, and the main issues, though, were not really wills issues, but there was kind of an interesting evidentiary issue. What the daughter wanted to get introduced into evidence was the fact that the parent, the testator, also had made lifetime gifts. And what she, in effect, was trying to do, though she didn't come out and say it, was trying to allege that these were in partial satisfaction of the testamentary gift. And the court said no. They never mentioned it, but really they should have said, this is irrelevant because you're trying to allege a satisfaction. And what do satisfactions have to be under modern law now in Texas? In writing. And so the fact that you didn't have a writing would have prevented these from being satisfaction in the first place. Next, we have cases dealing with will contests. That's going to be our last wills topic. And we have two cases dealing with will contests that merit our attention. The first is the in the estate of Paris Musa case out of San Antonio. And petition has been filed on this case. Now, what happened here is the trial court dismissed the will contestant's action for lack of standing because they said that she was stopped from contesting the will because she had already accepted benefits under the will. In other words, you can't have your cake and eat it too. You can't accept benefits and then continue to contest. But the appellate court reversed. Now, they didn't reverse on the principle of law. They did recognize that a person who has standing to contest a will may lose that standing if the person accepts benefits under the will. But the court explained from two perspectives that the contestant did not actually accept benefits under the will. Now, in one situation, the contestant did receive estate property, but it was through a convoluted method. The property went from the testator's estate to the beneficiary under the will, who gave it to a third party, and then the third party gave it to the person contesting the will. And the court said that that chain of custody kind of took it away from that she was receiving property under the will. And then the allegation was made that she accepted benefits under the will because she took as the beneficiary of a pay-on-death bank account. And the court rejected that as well because property that passes through a pay-on-death account, of course, does not go through the estate. But there was more in the case because this woman here who was contesting, she also was a big liar. She had perjured herself over and over again in affidavits. And the court was real upset with her perjury and dismissed the contest as a sanction. They issued the death penalty sanction and dismissed it because she was nothing but a liar and a perjurer. And the appellate court said, yeah, she's a liar and a perjurer, but the death penalty sanction was too extreme because it deprived her of due process. And so despite the fact that she lied a lot too, they allowed the action to continue. Now the next case dealing with will contests we want to look at is an undue influence case. And this is strange, and I have no idea about this. The case was decided by the Texarkana court in 2009, but it was just released and published in the last couple of months. Why the case was delayed for 5 years, I have no clue about. And if any of you know about the In Re Estate of Reno case, I would love to know why there was this big delay. Anyways, what happened in this case, and since, even though it's not that new of a case, it's new to me, so we're going to talk about it. And that is, the testatrix wrote a will and a codicil in the early 2000s, and another will in 2007. And after her death, the children of her first marriage probated the first will and obtained a ruling that she was incompetent to execute the second will. And of course, the proponent of the will appealed. Now, this is what happened. The court agreed with the proponent. I mean, this was written pretty good. Agreed with the proponent of the will that there was insufficient evidence to support that the testatrix lacked capacity. So we had someone, they said, yes, they have capacity, but then they lost on the second claim, and that is, they said there were plenty enough evidence to support the trial court's decision not to admit the new will because she had been unduly influenced. Now, of course, as you know, when people do undue influence, they rarely do it in a way that there's witnesses, right? When you want to unduly influence someone, you don't do it with other people around. You sequester them somewhere, you do it to them, and then after they die, they can't testify that they were unduly influenced, and you're probably going to lie on the stand, right? It's not like they're going to crack. They're evil, they exert undue influence, and you put them on the stand, and all of a sudden they say, oh yeah, I did it. That doesn't happen. So you have to rely on circumstantial evidence. And the court said here that if you added up all the circumstantial evidence, you had enough to demonstrate undue influence. For example, the will was written by the proponent of the will without the intervention of a lawyer. And then the proponent took the testatrix, moved her into a nursing home, did not tell any family members that he had done so, and then told the nursing home not to tell anyone that she had now moved into the nursing home. And then she was susceptible to undue influence. She was weak mentally and physically. She was under hospice care. There was a huge difference in the wills. And although the court recognized that all this circumstantial evidence and any piece of it on its own was not enough to show undue influence, when you looked at all of it together, there was enough evidence to support the jury's finding of undue influence. So, those are our wills cases. Now it's time to move on to cases dealing with estate administration. And there are 3 cases dealing with jurisdictional issues in your materials. We only have time, though, to talk about 2 of them. The first deals with a family settlement agreement. It's the Carter case out of Austin. And here everything went really great. The siblings got together, and the estate plan had left the property to the siblings in unequal shares. And rather than fighting, they all got together. They kumbaya'd together, and they decided to agree to share the estate in approximately equal shares. Everything was great. And they also agreed on a particular sibling to serve as the independent executor. Years go by. Now one of the siblings is kind of upset about what's going on and demands an accounting. And that sibling who was named as the executor said, oh no, you can't do anything like that because that family settlement agreement means that the court no longer has any jurisdiction over this case, and you no longer can complain about anything I do. Well, the trial court said that was nonsense, but that the sibling executor appealed anyways, and the appellate court affirmed and said, hey, just because there's a family settlement agreement, that does not mean you no longer can go to court if you find that people are breaching fiduciary duties, etc. So we learned from that case, of course, that a family settlement agreement is not going to deprive a court of its jurisdiction. The second jurisdictional case is the Diaz versus Elkin case out of Houston. And this dealt with a case where the personal representative was appointed by the courts of Peru, but she happened to live here. And they wanted to sue her for breach of her fiduciary duties with regard to the estate in Peru. And the court said, hey, there's no property here in Texas, and that we're not going to have any jurisdiction, even though it just happens that the fiduciary lives here. Now, the next cases we want to look at deal with venue. And these were some unusual rulings with regard to venue. I don't say unusual, it's just that they dealt with venue issues that perhaps you're not familiar with. I know that some of these I was not familiar with until after these cases. The first case is the In re San Jacinto County case out of Houston. And what happened here is there was an estate administration ongoing in Harris County, which was the county the testator was domiciled in at the time of death, just exactly to what you would expect. And then an issue arose regarding the proper venue for a declaratory judgment action that would impact property the testator had devised actually to San Jacinto County. San Jacinto County was the devisee. And the independent executor said, you know, venue's here in Harris County. This is where the estate is being administered. San Jacinto County said, no, the venue is in San Jacinto County. And the probate court said, come on, the estate is being administered in Harris County. That is where venue is. Well, San Jacinto County was upset. And so they went and got a writ of mandamus, and the appellate court conditionally granted that writ because they said, hey, you've got to read the Civil Practice and Remedies Code, section 15.015. And this is a mandatory venue provision that says that actions against a county must be brought in that county. And so you learn from this that if a probate court judgment could potentially result in a judgment against a county, proper venue for that action is in that county. The next venue case dealt with tortious interference with inheritance rights, the In re Hanna case out of Houston. And a dispute here again arose about what court had venue over a tortious interference with inheritance rights claim. The plaintiff filed suit in one of the counties in which a tortfeasor was domiciled. And the defendant said, no, you can't do that. This relates to a probate proceeding, and it should be heard in the county in which the decedent was domiciled at the time of death. And of course, the judge didn't want anything to do with this. I wouldn't either. And so the judge said, yeah, that's right, and transferred the case. And the plaintiff then sought a writ of mandamus, and the appellate court granted that writ because the court focused on the definition of a probate proceeding. And the court said, look, this is no probate proceeding. This is an action for monetary damages for a tort action. There is no will contest. There's no claim of heirship. There's no claim that the decedent owed money to the plaintiff. There was no probate law going to be involved in the decision, and any judgment was going to take money out of the defendant's pockets, not out of the decedent's estate, and therefore the trial judge abused his or her discretion in not following the plaintiff's election to have venue in the county where one of the defendants was domiciled. Now, our next case deals with another procedural issue, transfer. It's the In re Estate Trevino case out of San Antonio. All right, testator's wife filed the testator's will for probate in the Constitutional County Court. Remember, that makes perfect sense. The county didn't have a statutory probate court or a county court at law exercising probate jurisdiction. But the interesting thing is that husband died in the morning and she filed the will for probate in the afternoon. I mean, that guy wasn't even all the way cold yet, and she's filing the will for probate. And a few days later, she filed an action against the testator's son, alleging that he breached fiduciary duties and was and that he exerted undue influence. And then the probate court judge, the constitutional county court judge said, hey, I don't want to mess with this. And so I'm going to use my authority under the probate code / estates code and transfer this case to a district court and wash my hands of it because I have the right to do that when there is a contest. And the testator's son objected to this. In fact, he wanted the assignment of a statutory probate court judge. And the trial judge rejected all of this. And so the son requested a writ of mandamus. And guess what? The appellate court granted it. And the court said, you know, Judge, you do have the right to transfer the case to the district court when there is a contest. But guess what? There is no contest yet. You just think that there's going to be one. And it's irrelevant that the testator's wife anticipated that the testator's son would file a contest, that the court, they're not psychic. You can't see. I pretty much could see that a contest was coming down the road, but until it actually comes, you can't transfer the case, and therefore the transfer to the district court was improper. So don't ask a court to perform an action like this prematurely. Wait for the contest to actually be filed. The next case deals with whether or not a particular person can be deemed an interested person to have standing in a probate proceeding. This is the In re McDonald case out of Beaumont. Now, the father of the deceased son said, look, I have standing for two reasons. One, I am a creditor. I paid for the son's funeral expenses. And second, my grandson, the testator's son, is a minor, and I am interested in the welfare of the minor child. And the trial court said, being a creditor and being interested in the welfare of your grandson, that is not enough. That does not give you any right to participate in the probate proceedings. And the father, he's kind of mad here, and so he appealed, and the appellate court said, trial court, you're wrong. He has plenty of standing. First, he paid for the funeral. He is a creditor. They tried to get around that and said, what the wife did is she said, look, I've deposited with the registry of the court enough money to cover the funeral expenses to remove his interest. And the appellate court said no, because there's no way of knowing that money will actually go to him later on just because the money is there. There could be other creditors with priority. There could be an executor appointed who doesn't agree with the claim. Who knows? And second, he certainly has standing because of his grandson. The grandson was in the custody of the grandfather. That's who the Department of Family and Protective Services had put the kid in the custody of, and he certainly had standing in that role. So the trial judge was incorrect in saying there was no standing on those grounds. Now, the next two cases we have in the materials deal with appeals. We only have time, though, to look at one of them, and that's the Estate of Fisher case out of Texarkana. The testator's will was filed for probate, and the contestant said, this will was the product of undue influence. And the trial court looked at it and said, there is absolutely no fact issue dealing with undue influence. You're just making it up. And so they issued a partial, no evidence, summary judgment against the contestant. The contestant then filed for an accelerated permissive appeal under the Civil Practice and Remedies Code. And the appellate court said, hey, we don't have any jurisdiction over this. Now, why was that? The court said, look, a summary judgment is an interlocutory order and not appealable. However, if you qualify under this special accelerated permissive appeal provision, then you can bring the action. And the court, though, said, before you can bring one of these accelerated appeals, you have to have a question of law, a legal question that you are debating. In this case, there was no legal question being debated. It was simply a matter of fact. In other words, whether or not there was or was not sufficient evidence of undue influence to preclude a summary judgment. And so the contestant is just going to have to wait to appeal to a later time, such as when there's actually an order admitting the will to probate. The next case we want to look at deals with a late probate. As you all know, you're supposed to probate the will within 4 years of the decedent's death unless the proponent can prove that the proponent is not in default. And you know that the Texas courts have been very liberal in accepting all sorts of reasons why a person was late in probating a will, including provisions such like, I was dumb, I didn't know I was supposed to probate a will, and there are some courts that have bought that. Well, what happened in this case is the testatrix died in 1992, and her will was not probated. Then in 2006, one of the testatrix's daughters died, and then her daughter, which would be the granddaughter, found the testatrix's will, told her sister about it, and gave a copy of it to her uncle back in 2007. And then the sister, who was told about the will, filed an application to probate the testatrix's will in 2012. And the wife here opposed the application, saying, hey, you were supposed to probate that will in a timely manner. And there was actually two different issues in here. The first issue was whether or not we could ascribe the default of a prior person who was definitely in default to a later person. And the court explained that the Texas courts are in debate as to whether or not we can ascribe a default of a later person to that later person's successors in interest. That there's cases going both ways. But the court said, we don't have to reach any of that stuff, because in this case, more than 4 years went by, and she didn't have any excuse for why she waited more than 4 years after she became fully aware of the will. So what we learn here is that if you have a stale will and you discover it, how about probating it in a timely manner? You should take care of business right away. Do not delay. Otherwise, you will be deemed in default. Now, our last estate administration case deals with something near and dear to many of your hearts. Attorney fees. And that's the Jones case out of Dallas. What happened here is that the independent executor said to the beneficiary, hey, you've taken property prematurely. This property has to go through the estate administration process and be properly administered. Give it back. The beneficiary said, no, I went shopping after the testator died, and I took the stuff I wanted. I'm not giving any of it back. And so they went to court. And of course, the court issued a writ of mandamus to force the beneficiary to give back the property. And that was great. But the executrix also said, the probate court should now award attorney fees against the beneficiary. The probate court said, sorry, that would be nice if we could, but we can't do that. Well, the executor was mad and said, yes, you can, and therefore appealed, but the appellate court affirmed, saying that the probate court does not have discretion to hold the beneficiary responsible for the attorney fees. Instead, it is the estate that's responsible for those fees. They explained that Texas still follows the American rule that fee awards are not allowed unless they are expressly authorized by a statute or by a contractual agreement between the parties. And the court closely examined our statute and found there was no basis for shifting the fees from the estate to the losing party. But the court, though, you could tell that they were sympathetic. It sure wasn't fair that the estate had to absorb the costs for going after an evil beneficiary who shopped, took the decedent's property, and then wouldn't give it back. And they said, they provided a little advice there. They said, why don't you think about getting attorney's fees under other statutes? How about alleging theft? And then maybe you could get it under the Texas Theft Liability Act. In other words, try to get the fees another way. I also want to point out, though, that this was a wills case, a decedent's estate case. Things are different in trusts. Remember, with trusts, Property Code 114.064 tells us that the court can make an award of costs and attorney fees against any party as long as it is, quote, equitable and just. So things are very different in a trust context because of that provision than we have in the decedent's estate provision. Well, since I just mentioned trusts, I guess that means it's time for us to look at a couple of trusts cases. So let me take a look here how much time I have left, see what cases I want to talk about. We're going to look at an interesting and probably significant case of Benavides versus Mathis. This is a case out of San Antonio dealing with an issue which has been debated for many decades in Texas and which always seems to render lots of different experts with different opinions. And that is how to correctly determine income and principal from certain types of trusts. So what happened here? A court determined that a beneficiary of a trust was incompetent and appointed a guardian of the estate. So far, so good. But then a dispute arose with regard to the person entitled to trust income. In other words, the beneficiary who was declared incompetent was the beneficiary of the trust. And how is the income going to be distributed? The guardian said that because the settlor of this trust had created the trust prior to the date the beneficiary was married, the income from the trust is separate property. On the other hand, the beneficiary's wife said, don't you know Texas law that income from separate property is community property, and therefore I should be entitled to 1/2 of the income because it is community property? Well, both the trial court and the appellate court ruled in favor of the guardian, indicating that it was separate property. The court did recognize the basic rule that ordinarily income from separate property is community property. But they said in this case, because the trust was irrevocable and the beneficiary had no present possessory rights to any of the corpus, that it was going to remain separate property. We have, this area is, like I said earlier, a hotly debated one. There are learned articles on both sides here. So there was kind of a hope, a lot of us were hoping that the Supreme Court would take this case. And instead they said, we'll just deny petition on it. And so we could have had some nice, clear law on it, but we do not. All right. The next case we want to look at deals with deviation, changing the terms of the trust by agreement. This is the In re Willa Peters case out of San Antonio. And what happened here is the parties all got together and they agreed on certain modifications. And of course, after you reach a settlement and agree to modifications, what was one person going to have later on? Settlement remorse. Right? They're going to say, man, I shouldn't have agreed to that. And they came up with the argument here that our deviation statute allows beneficiaries to agree to changes as long as they are not against the material purposes of the trust, and that some of the changes that were agreed to were against the material provisions of this trust. And the appellate court looked at it, and the appellate court said, yeah, you're right. Some of these changes do impact material purposes, and therefore the court had no authority to grant deviation. So although our deviation statute is extremely broad, especially after revisions that were made a few years ago, you still cannot deviate away from the material provisions of the trust. Our last trust case deals with a breach of fiduciary duty. It's the Ward case out of Dallas, and this is a petition filed case. The beneficiary sued the trustee, alleging that the trustee did not timely attempt to collect on a promissory note which the settlor had executed payable to the trust. The big issue here was, when did the beneficiary's cause of action accrue? Now, the court, it's kind of interesting. There was a good interface here between wills law and commercial paper law, because there was a big debate whether this note was negotiable or not. I don't think most of you care about that part of it, but where's Professor Kramer? He'd like that part. Anyways, so the court decided it was negotiable, which means it has a 6-year statute of limitations. And the issue, like I said earlier, was, when does the cause of action accrue? The beneficiary said that it was the last date that the trustees could have sued on the note, without being barred by limitations. That would have given the longest period of time. The trustee said, the cause of action accrued on the first date the trustees could have sued. So do you see there's a 6-year differential there, right? Does it accrue at the end of the statute of limitations period, like the last day before you'd be barred by the statute? That's when you had to file suit. Or did you have to file suit on the first day, immediately when you saw the breach? The appellate court said, both of these views are wrong. They are both too extreme. You can't wait to the end, but you don't have to sue the first day the cause of action accrues either. And they said, somewhere in that 6-year period is the right time. And where in that 6-year period the right time is a question of fact, and therefore has to go back to determine when that date would have been and whether the trustees did or did not wait too long. Well, we have about 5 minutes left, and in those 5 minutes we're going to look at a few cases dealing with assorted other estate planning matters. The first one is an interesting case dealing with something that all of us fear: malpractice. It is the Mesner case out of Texarkana, just decided in January of this year. The administratrix filed suit against the attorney alleging malpractice for representation of two things: the decedent while the decedent was alive, and the executrix after the decedent died. And the appellate court split its opinion. They said, look, the administratrix has standing to pursue claims for malpractice which the decedent had while alive. Those are in the nature of a survival action, and that has been well established by the Texas courts through cases like Belt versus Oppenheimer. But they said with regard to the attorney fees to the executrix that those were not actions that the testator ever had. The decedent never had any type of action against the attorney for the executor, and therefore those were not ones that the estate could bring. I have one multiple party account case I want to talk to you about. It's the Hicks versus Texas case out of Amarillo. What happened here is that the defendant befriended her father-in-law. They opened a joint bank account. The defendant in the case then withdrew money from the account in excess of her net contributions, and she used those funds for various enhancements. She first enhanced herself with the money, physically, and then she used the money to enhance her house, bought appliances, and paid for cheerleading classes. And when all this came to light, she was convicted of theft, and she was given a new residence, an Iron Hotel in a gated community. Now, she was not very happy living there, and so she appealed. And the court did say that, look, a party to a joint account does have the right to withdraw all the funds. But if you withdraw more than your net contributions without evidence that you have permission, authority, or a gift is being made, that is theft, and therefore you are exactly where you belong. You belong in the cell, and you stay there. We now conclude with one last very interesting case, the Jackson case out of Amarillo, decided just February 13th. I mean, not even a month ago. Here's what happened. A jury said, hey, defendants, you are all guilty of tortiously interfering with inheritance rights. And the trial court awarded appropriate damages. Now, the defendants appealed, but their novel ground of appeal was this: they did not deny that they committed tortious interference. They said, oh, that's cool, we did it. But Texas does not recognize the tort of tortious interference. And in a very surprising, in my opinion, the Amarillo court said that's right. Now, this is interesting. It was actually a Fort Worth case, but it got transferred to the Amarillo case under some procedure the Supreme Court has for equalizing dockets. Anyways, so the majority opinion said, look, there is no Texas Supreme Court case that has recognized the tort, and therefore we can't. But the dissent pointed out that there are 6 Texas intermediate courts that have recognized the tort, including the Amarillo court that now said they don't recognize it. And then they said that 6 other districts, other circuits, have discussed the tort, not, just in passing, like the action had that action in it and so on. And so they just, that we have plenty authority of that. What I thought was the most interesting thing is that none of them pointed out the legislative recognition of the tort. Neither side cited a state's code 54.001, which is the new version of probate code section 10C, that says, quote, the filing or contesting in probate court of a pleading relating to a decedent's estate does not constitute tortious interference with inheritance of the estate. Why would the legislature say something cannot be tortious interference if Texas doesn't recognize tortious interference? Who knows? Maybe there will be a petition on that case. Anyways, my time is up. I hope our discussion of recent cases have brought you up to date with what the Texas courts have been doing, and that you can use this knowledge to enhance the advice that you give to your clients.
All right. No, all right. Thank you, Professor Beyer. I actually have the results of the vote. It looks like we'll be hearing from Professor Beyer on what estate planners need to know about firearms this afternoon.
We're in Texas!